words. Say good evening. I want to start by recognizing our Coast relatives on whose territory we're gathered this evening. So this evening, I want to spend some time talking about Indigenous land rights and talking about it from the perspective of the domestic law and the international law around this important area that has been developing for the past few years now. The domestic law here in Canada has a constitutional foundation, and we know that Section 35 of the Constitution of Canada recognizes the existing Aboriginal and treaty rights of the Aboriginal peoples, and those rights are recognized and affirmed. However, there is no legislative implementation framework for that Section 35. And so we have to rely on the common law in order to understand what Section 35 means and how Section 35 will be implemented. When we think of the common law in terms of Aboriginal rights, common law freedoms are not like human rights type freedoms or claims. The common law freedoms are built up as a general principle established by individual cases. And so in this area, we go back to the case of Calder, brought by the Nisga'a people many years ago in the 1970s. And that was the first case where Indigenous or First Nations rights to land was discussed by the Supreme Court of Canada and in modern times. And in that case, the governments argued that, well, all of the land rights of the First Nations in British Columbia have been extinguished. They no longer existed. This case went up to the Supreme Court of Canada, and the judges split. The Supreme Court of Canada split. 3 judges agreed with the Crown that, in fact, these land rights had been extinguished. 3 judges ruled that, in fact, those land rights had not been extinguished. And the 7th judge decided the case on a technicality and ruled that because the Nisga'a hadn't gotten permission to sue the government, that they were not able to get any kind of a declaration of title. But that started the process. So in the common law then, you have this precedent being established that in fact it was a question. Did the rights exist or did they not exist? The next case to go forward then was the Delgamuukw case. In Delgamuukw, the Gitxsan and Tsilhqot'in brought this case before the Supreme Court of Canada. And this time the Supreme Court of Canada ruled unanimously that in fact the land rights of Indigenous peoples in British Columbia had not been extinguished. So that was the next progressive step. And they outlined a number of factors that need to be taken into consideration. But again, the Gitxsan and Tsilhqot'in didn't get a declaration of title because the Supreme Court said, well, the trial judge had so misinterpreted and misapplied the facts of the case that it made it impossible for them to issue a declaration of title in that case. So, they sent the case back to be retried. And because the Gitxsan and the Tsilhqot'in haven't been able to have the financial resources to start over again, that case has not been retried and continues to wait. But it moved the law forward. So now you see this gradual kind of way that the common law evolves. You move from Calder to Delgamuukw. So now you've gotten so far as to say, well, the rights exist. And they've given some parameters around the rights. The next case to move forward was the Williams case. The Tsilhqot'in people brought a land claim case. And this case has now been argued at the Supreme Court of Canada. And in this case, then, the Tsilhqot'in people, again, are arguing and have argued that their land rights should be recognized by the Government of Canada and the Government of British Columbia. And again, the governments are arguing against the recognition of those land rights. When we look at the BC Court of Appeal, which is the decision that went up to the Supreme Court of Canada, here's what the judges in the BC Court of Appeal had to say. Aboriginal nations were not recognized as nation states by the European nations colonizing North America. European explorers considered that by virtue of the principle of discovery, or the doctrine of discovery, they were at liberty to claim territory in North America on behalf of their sovereigns. And then the Supreme Court said, or the Court of Appeal said this: while it is difficult to rationalize this view from a modern perspective, the history is clear. There was from the outset never any doubt that sovereignty and legislative power, indeed the underlying title to such lands, vested in the Crown. So that was the beginning point for the Court of Appeal. They then went on and said that exploiting the land, the rivers, the seaways for hunting, fishing, and other resources may translate into Aboriginal title to the land if the activity was sufficiently regular and exclusive to comport with title at common law. So now you see them beginning and carrying on with some of the comments that were made by the Supreme Court of Canada in terms of, well, what does First Nations have to prove in order to establish their title to the land? And they then go on and say it supports the view that title must be claimed on a site-specific basis, and that a certain regularity and intensity of presence is needed before it will count as occupancy. They go on. The problem for the Tsilhqot'in is that mere occupation of land does not necessarily establish Aboriginal title. If an Aboriginal group has used lands only for certain limited activities and not intensively, the group might have an Aboriginal right to carry on those activities, but it does not have title. So now the court pushes it even further. They say not only do you have to establish that you used the land, but you have to establish that you used it exclusively and that you used it intensively. They go on. Case law does not support the idea that title can be proven based on a limited presence in a broad territory. So again, they constrict how and where First Nations or Aboriginal peoples can establish title. Rather, Aboriginal title must be proven on a site-specific basis. A title site might be defined by a particular occupation of the land, for example, village sites, enclosed or cultivated fields, or on the basis of definite tracts of land where that were the subject of intensive use, specific hunting, fishing, gathering, and spiritual sites. They went so far as to say, for example, the rock that you stood on when you went to fish. So they began to narrow this concept of title down to these very specific sites. In all cases, however, Aboriginal title can only be proven over a definite tract of land, the boundaries of which are reasonably capable of definition. So again, you see what the courts are doing. They're narrowing down under the common law where First Nations are able to establish title to land. They go on. This view of Aboriginal title and Aboriginal rights is fully consistent with the case law. So again, common law. It is also consistent with the broader goals of reconciliation. So now the court moves from this sort of legal analysis of this, and they move into sort of policy considerations, reconciliation. There is a need to search out a practical compromise that can protect Aboriginal traditions, not rights, but traditions, without unnecessarily interfering with Crown sovereignty and with the well-being of all Canadians. An overly broad recognition of Aboriginal title is not conducive to these goals. So you see the Court of Appeal begins to narrow down legally the rights of First Nations, Indigenous peoples under the law, and they also begin to narrow it down in policy under this concept of reconciliation. So they begin to take a very restricted view of what title is. That case has been appealed to the Supreme Court of Canada. It has been argued. And in that case, the Tsilhqot'in Treaty Group and Amnesty International intervened at the Supreme Court of Canada level. I argued the case for Tsilhqot'in, and we argued that the Supreme Court should begin to incorporate international law into domestic Aboriginal law. The Tsilhqot'in Treaty Group submitted that there is an implementation gap of domestic and international law respecting Aboriginal rights, as evidenced in the admissibility report of the Inter-American Commission on Human Rights in the Tsilhqot'in case, being satisfied that there were no effective domestic remedies to address the resolution of the Aboriginal land issues that the Tsilhqot'in Treaty Group had raised. And we'll get into that in a little bit. We also submitted that the current land claim litigation and treaty negotiation processes are too lengthy, too costly, too complicated, too inflexible, and uncertain. And if the Court of Appeal's decision or opinion is upheld, it will become even more so. So Tsilhqot'in Treaty Group lastly submitted that the only acceptable practical compromise is to construct a new paradigm based on the promotion and protection of human rights by integrating the framework of international law principles dealing with Indigenous human rights into the fabric of the domestic Aboriginal rights law to provide a way forward to achieving reconciliation through more effective processes. So when we look at this notion of international law then in relation to human rights, that draws from a number of sources. The Charter of the United Nations talks about equal rights. It talks about self-determination, about the promotion of respect. The Universal Declaration of Human Rights talks about the right of everyone to own property, alone or in association with others. The International Covenant on Civil and Political Rights, again, talks about self-determination. Article 27 talks about states or countries where there are ethnic or religious or linguistic minorities, that those persons should have the right to enjoy their own culture, their own religions, their own languages. The International Labor Organization has passed an article, 169, Convention 169, which addresses Aboriginal or Indigenous people's rights. And in that, Article 14 talks about the right of ownership and possession over lands that they traditionally occupied should be recognized. Particular attention should be paid to situations of nomadic peoples. And it's interesting that in the BC Court of Appeals decision in Tsilhqot'in, this was one of the things that they highlighted. They highlighted the fact that the Tsilhqot'in people were nomadic. And because they were nomadic, it somehow undermined their right to hold ownership of land. Here we see, the international principles here are different. That governments should take steps take steps as necessary to identify the lands traditionally occupied to guarantee effective protection of their rights of ownership and possession, and that adequate procedures shall be established within the national legal systems. Here in the Americas, under the Organization of American States, of which Canada is a member, the American Convention on Human Rights, which Canada has not signed on to, has not signed this international treaty. Under that treaty, it talks about the right to equality. It talks about the right to property. So we have this framework of international law that has been established and continues to grow. And how is that interpreted in terms of the rights of Indigenous peoples? How do these international instruments relate to Indigenous peoples? Well, the Inter-American human rights system is taking a very progressive and active approach to indigenous human rights to property. They have linked indigenous human rights over traditional lands to established notions of property. Central to this approach is the principle that possession of land per se qualifies for international legal recognition, notwithstanding the community's lack of real title under their domestic laws. So that's the general approach that has been taken by the Inter-American human rights system. Now, what I want to do now is just talk about some of the cases that they have dealt with. So the first one was the first case to be dealt with, which is the case of the Awas people in Nicaragua. The Awas people in Nicaragua were contesting the fact that the government of Nicaragua had granted concessions to international logging companies to log over their traditional lands, and that the Nicaraguan government had not recognized the Agustini people's right to land and had not issued titles or demarcated those lands. So the argument, again, was that Nicaragua had violated the right to property by granting these concessions and by not titling and demarcating, that the right to property includes the collective right of indigenous peoples to enjoy their traditional lands and natural resources. So it was being argued that the Agustini people in Nicaragua should have the same human rights as other people, that they should have the same protection of that framework of human rights to property as other people. They argued that Nicaragua had violated the right to an effective remedy by failing to ensure the enjoyment of the indigenous land rights that are affirmed in the Nicaraguan Constitution and laws. They said that for indigenous communities, the relation to the lands are not merely a matter of possession and production, but a material and spiritual element which they must fully enjoy, even to preserve their cultural legacy and transmit it to future generations. The court in this case said that the Nicaragua must cease acts which could cause the agents of the states or third parties to affect the existence, value, use, and enjoyment of the property of the Awastini community. That Nicaragua must adopt measures of legislative, administrative, and whatever other character for the effective delimitation, demarcation, and titling of indigenous lands. The land titling process must be in accordance with the customary law, values, usage, and customs of the communities and with their full participation. So you can see that this is beginning to be a much different picture than what we have in Canada. The next case is the case of Dann versus the United States. In this case, the Dann sisters were from the Western Shoshone people in Nevada in the United States. And they were subject to United States government confiscating horses that they were raising and so forth. And that for two decades, they had asserted that Aboriginal title rights to the Western Shoshone's ancestral lands, and that the United States had considered that these had been extinguished by gradual encroachment, including large-scale gold mining and other environmentally damaging activity on these lands that were still being used by the Western Shoshone. They went to the Supreme Court of the United States and were not successful, so they went to the Inter-American human rights system. And after consideration, the commission concluded that the violations that they were asserting were continuing and ongoing and were a prima facie violation of the rights protected by the Inter-American human rights system. And on that, they declared that the Dann case was admissible. In that case, the Inter-American Commission, because like Canada, they haven't signed on to the treaty with respect to the Inter-American Convention on Human Rights, so that they couldn't go to the court. They could only go as far as the commission. But the commission said that the United States had failed to adequately address the Western Shoshone claim to ancestral lands through administrative and judicial proceedings. The commission used an evolution approach in interpreting the obligation of the United States under the American Declaration by applying the entire spectrum of international human rights legal developments relevant to indigenous peoples, including rights under the UN and other international instruments. So the United States was arguing, as Canada has argued in our case, well, we didn't sign on to that treaty, so it doesn't apply to us. So therefore, we don't have to abide by it. In this case, the Inter-American Commission said, well, we're not looking at it just from the perspective of that one treaty. And the fact that you didn't sign on to that treaty isn't good enough to say that it doesn't apply to you. Because we're going to look at the broad spectrum of international law. And we're going to say that, this broad spectrum of international law applies. And we will apply it to this case. They ruled that where property and user rights of indigenous peoples arise from rights existing prior to the creation of a state, indigenous peoples have the right to recognition by that state of the permanent and inalienable title of indigenous peoples relative thereto, and to have such title changed only by mutual consent between the state and the representative indigenous peoples where they have full knowledge and appreciation of the nature or attributes of such property. This also implies the right to fair compensation in the event that such property and user rights are irrevocably lost. So we see now that the Inter-American human rights system is pushing this even further. They're saying, okay, in the case of the United States, even though you haven't signed on to that treaty, we're still going to apply international law. Even though these things happened prior to the creation of the state, indigenous people still have rights to those lands, and it can only be changed with their mutual consent. And they have to have full knowledge and appreciation of the attributes of the property, and if they cannot get the land back, that they're entitled to fair compensation. So we see that this international human rights system is pushing the law way beyond what the Court of Appeal in Canada has done. And here's where they develop further these concepts that human rights are live instruments whose interpretation must go hand in hand with the evolution of the times and current living conditions. The court has stated that interpretation of a treaty should take into account not only the agreements and documents directly related to it, but also the system to which it is a part, and they make reference to the Vienna Convention. In the instant case, in its analysis of the scope of the convention, the court deemed it useful and appropriate to resort to other international treaties, aside from the American Convention, such as ILO 169, to interpret the provisions in accordance with the evolution of the inter-American system, taking into account related developments of international human rights law. The corpus juris of international human rights law comprises a set of international instruments of varied content and juridical effects, treaties, conventions, resolutions, declarations. In its dynamic evolution, it has had a positive impact on international law in affirming and building up the latter's faculty for regulating relations between states and the human beings within their respective jurisdictions. This court, therefore, must adopt the proper approach to consider this question in the context of the evolution of fundamental rights of the human person in contemporary international law. And lastly, the case that we brought to the Inter-American Commission in Washington, D.C., the Tsilhqot'in Treaty Group versus Canada. In our case, in the admissibility ruling, the Inter-American Commission found that by failing to resolve our claim with regard to ancestral lands, the BC treaty process has demonstrated that it is not an effective mechanism to protect the right, because that's what Canada was arguing. Well, in British Columbia, you have the BC Treaty process, and there are nations that are involved in that, therefore you have an effective remedy. The treaty, the Inter-American Commission agreed that this was not an effective process. It's been 21 years, and we have 2 treaties. They also said that, that they found that the government's position that nations that do not wish to accept their terms of negotiation can litigate. And so you go back to the comments that they had made previously, that just because you can go to court doesn't mean that the rights are protected. And they said that they noted that there was no due process of law to protect the property rights of the Tsilhqot'in people to its ancestral lands. They observed that the government of Canada had argued, well, look at all this, look at Calder, look at Delgamuukw. It demonstrates that our legal system is effective, that our legal system is fair, that the Tsilhqot'in people will get a fair shake if they go to court. The commission agreed with us that there has been no legal case on Aboriginal title that has been favorable, and they agreed that none of the cases that were argued seem to provide any reasonable expectation of success, because Canadian jurisprudence has not obligated the state to set boundaries to demarcate and record title deeds of land of the Indigenous peoples, and that these remedies would not be effective under recognized principles of international law. So as a result of that, they found that there was a prima facie case that moved us forward to the merits that Canada was violating the Tsilhqot'in people's right to equality, the right to religion, the right to culture, and the right to property. So we can see that these 2 legal systems, the domestic legal system and the international legal system, are really dealing with the same topic, but they're going about it in very different ways. Under Canadian jurisprudence, it's this slow building case upon case, precedent upon precedent, that are taking many, many, many years to try and resolve. What's going to happen in the Williams case, we're not sure. Whether the Supreme Court of Canada will agree with the BC Court of Appeal, and that is that First Nations are only entitled to have property rights to these very small areas and not to territorial areas, or whether the Supreme Court of Canada will in fact begin to look at a much more progressive way of dealing with Indigenous land rights, such as is being developed by the international human rights system, in terms of looking at a much broader scope of rights and how to resolve those rights, and saying that states like Canada have an obligation to establish effective systems. Is it effective when it's taking, the Tsilhqot'ins have been in court over 20 years. The Tsilhqot'in people have been at the negotiating table for over 20 years. So are these really effective? So those are some observations in terms of this issue of domestic and international jurisprudence. And I want to thank you for coming out this evening and listening.